A lawyer was retained by a husband and wife to assist with completing a residential real estate purchase of what was to be their primary residence. Years after the transaction had closed, one late Friday afternoon, the lawyer received a panic call from the wife. It was a call the lawyer would never forget. The wife advised the lawyer that her husband had recently passed away, and when she proceeded to take steps to transmit title to their home into her name, a home that her and her husband had been living in for well over 10 years, she was shocked to discover that contrary to their mutual instructions, title to their home had been registered to them as tenants in common, as opposed to joint tenants. Obviously, the lawyer took immediate steps to recover the original file from closed storage. While the lawyer was waiting for the file, she couldn't help but think perhaps the wife's recollection was correct. The wife had told the lawyer that her and her husband had been happily married for well over 25 years, and during that time, they had purchased other properties, all of which were held in their names as joint tenants. The lawyer could also remember the wife saying that all their other assets, such as banking and investment accounts, had been held in their names as joint tenants. When the lawyer reviewed the file, she noted that indeed the original instructions from her clients were to register the property into their names as joint tenants. As a matter of fact, located at the top of the conveyance file was a copy of her reporting letter addressed to both the husband and the wife, stating that not only the purchase transaction had closed successfully, but also that property was held in their names as joint tenants. The lawyer also examined a copy of this original state of title certificate that she had enclosed with her reporting letter, and it was at that time the reality of what happened hit her. She had not only failed to ensure that the Form A transfer had been prepared in accordance with her client's express instructions, but she had also failed to review the Form A transfer both prior to it being sent out to the vendor's lawyer for execution, but also before it was actually filed at the Land Title Registry. As a result of the erroneous registration, the husband's will may need to be probated, which meant the wife would be forced to pay as much as $25,000 in unanticipated fees and costs associated with probating her late husband's will. To make matters worse, the husband had children from a previous marriage. So there was the added risk of a potential WVA claim being asserted by one or both of these children. If a successful WVA claim was made, the wife could quite possibly end up losing more than just the fees and disbursements associated with probating her husband's will, but also lose up to an amount equivalent to half the value of the home, plus the additional cost of having to deal with a WVA claim. Thankfully, in the end, the matter was fixed by obtaining a court-ordered rectification of the title.